The Supreme Court today turned down an application by the petitioner, John Dramani Mahama, to reopen his case. Now, this was necessitated by the first and second respondents, indicating that they will not file any witnesses with regards to this case. Also, the Supreme Court indicated that it could not compel the EC chairperson, Jean Mensah, to mount the witness box, and this forced the legal team of the petitioner to reopen or to file an application to reopen the case which was turned down today. What were the reasons given by the Supreme Court for turning down this decision? Here's a wrap of what happened in the courtroom by my colleague Sixto Sudong Olo.
While the parties were waiting with bated breath on the Supreme Court to deliver its ruling on Tuesday, lawyers for former President John Mahama sprang yet another surprise. Captured on the letterhead of Lita Brew and Company, and addressed to the Chief Justice Enin Yeboah under the signature of Mr. Mahama's solicitor, Tony Litha, the former president's lawyer asked the court to grant leave for them to further argue the application for leave to reopen their case. This plea was hinged on a question Mafusau JSC had asked at the last adjourned date on whether or not the court, per an earlier ruling, had not placed a judicial bar on Mrs. Jean Mensah testifying as a witness in the ongoing election petition hearing. Per this prayer to the president of the court, Mr. Mahama's lawyers intended to provide the court with authorities on this question of judicial bar. They intended to rely on provisions of the Constitution 1992 as well as case law in their quest. But the letter did not find favor in the bosom of the Chief Justice.
And we have attached to our letter to your lordships, we have attached some of the authorities that we intend to rely upon in order to make clear that the position that we have taken or that we are taking in respect of that point that was raised is the legally accurate position, and we believe that it will be in the interest of justice that we all be given a chance to make arguments on the matter.
Counsel, with due respect, it's a legal point, and we've taken notice of it. Yes. So don't worry. It is a legal point which the authorities have been cited. You certainly look at it.
The court proceeded to deliver its ruling on whether or not former President Mahama could reopen his case. But first, on the invocation of its inherent jurisdiction, the court said,
"The court exercises its inherent jurisdiction inter alia to correct errors in procedure and to ensure that no miscarriage of justice is occasioned during a trial. Inherent jurisdiction, which is also referred to as the inherent powers doctrine, is the principle that allows courts to deal with various matters over which they have intrinsic authority. The petitioner has not demonstrated to us in any way that the decision of the respondent not to testify, which was upheld by this court in its ruling of 11 February 2021, has occasioned him any miscarriage of justice. That decision is backed by law, particularly our rules of procedure, case law, and settled practice."
The court also disagreed with the petitioner's argument that the instant application was an opportunity for Mrs. Jean Mensah to redeem herself.
Legal counsel for the petitioner urged on the court that he wanted the chairperson of first respondent to testify as an adverse witness of the petitioner. Counsel also made references to paragraphs 31, 32, and 33 of the affidavit in support of the application as to why he wanted the chairperson of the first respondent to testify. The other point petitioner's lawyer kept urging on the court was that the chairperson performs an important constitutional duty and must be made to account to the people for her stewardship and to vindicate herself. The question is, how can the chairperson of first respondent vindicate herself when he is not on trial before us? He was neither being personally sued nor arraigned before this court on any complaint or accusation, civil or criminal, for which he was to explain or account to anybody for anything he has done or not done. It is the institution, the Electoral Commission, which he has that has been accused by petitioner of not having performed its constitutional duty according to law. That the petitioner need the personal testimony of the chairperson of the institution sued before he could prove or establish the alleged non-performance of his constitutional duty by the first respondent. We do not think so.
And on the question of whether or not Mrs. Jean Mensah, who was returning officer for the December 2020 presidential poll, could be brought in as a hostile witness, this is what the court said.
What indeed baffles this court is the intimation by counsel for the petitioner that he intends to call the chairperson of first respondent as an adverse witness. Black's Law Dictionary, 9th edition, edited by Brian A. Garner, defined a hostile witness as, quote, a witness who is biased against the examining party, who is unwilling to testify, and who is identified with an adverse party, also termed adverse witness, end of quote. A hostile or adverse witness, as the definition shows, as we understand the term in practice, is therefore a witness who has been called by a party to testify in support of his or her case, and who, whilst in the witness box under examination in chief, performs hostile and gives evidence contrary to the party who called him and in support of the opponent's case. The party in such circumstances can apply to the court to treat such a witness who is already in the witness box as a hostile or adverse witness. This would enable the party calling him to cross-examine him as if he is a witness of his opponent to solicit the truth in respect of the issue at stake. A witness who has not yet entered the witness box to testify cannot therefore be called an adverse or hostile witness under any circumstances.
But on the substance of the petitioner's argument for its case to be reopened, how did its lawyers discharge themselves?
He is not entitled to his prayer as of right. It is subject to our discretion, and before we can exercise our discretion in his favor, we must satisfy certain basic conditions as laid down by case law. The general expectation imposed on all litigating parties is to place the whole of their case before the court at the time of the hearing. The process of invoking the inherent jurisdiction of the court at the close of the case of the party to reopen a closed case in order to adduce fresh or further evidence is thus an necessary step which the importance of finality of litigation fronts upon, save the presence of exceptional circumstances.
For the avoidance of doubt, the Supreme Court maintained that Mrs. Jean Mensah at no point gave indication of her willingness and readiness to testify and be cross-examined on the matters related to this election petition, and the application was dismissed.
For the above stated reasons, we find no merit whatsoever in the petitioner's application to reopen his case for the sole purpose of compelling his adversary's intended witness to testify through a subpoena without indicating the sort of evidence he intends to solicit from the said witness and how that evidence is going to help the court in resolving the dispute before us. We accordingly refuse the application and proceed without any hesitation to dismiss him.
For the respondents, i.e. President Akufo-Addo and the Electoral Commission, this ruling was to be the end of the matter, but not for the venerable and tenacious Chachu Chikata. He immediately serves notice of 2 applications filed ostensibly in response to the ruling.
My lords, I wish to notify your lordships that we have filed this morning, just this in the last half hour. So we have filed an application for review of your ruling of 11th February. And in connection with that, we are also filing an application for stay of proceedings pending the hearing of that review application.
Until Thursday, February 18, 2021, the court's directive for parties to file their closing addresses remains effective.
And I don't think that the date has been given yet.
Okay, so we already indicated that this case has been adjourned to Thursday, so you will come on Thursday. Yes. If the motion is fixed for tomorrow, then we can come and take the motion. Yes. If it is for Thursday, you will come and take the Thursday, but our orders still stand. So the court stands adjourned to Thursday.
now hear from spokespersons of the petitioner and the second respondent on what they make of today's ruling.
In our view, the court was wrong. In our view, the reasons of the court were based upon wrong legal premises. But the Supreme Court is the final decision maker when it comes to the law. And we have no reason not. We are bound by what it has said, this morning. We cannot depart, from it. But lead counsel for the petitioner has indicated that he is filing an application for review with respect to the earlier decision rendered on the 11th of February relating to their decision with respect to the compellability of the witness testimony of the Electoral Commission. The Supreme Court asked itself a question which we deem was a wrong question and answered that question. It said, why does the chairperson need to account to the people of Ghana when she is not a party to the suit? Now, you recall that counsel made it very clear that one of the reasons why we are in court is because of the unconstitutional conduct of Mrs. Jane Aduke Mensah as the returning officer under the Constitution. And it is not true that there is only one issue that needs to be determined in this matter. I am surprised that the Supreme Court itself, having set down 5 key issues to be determined, is now reducing the issues to one. But we had made abundantly clear in the petition that there were a number of infractions. We are contesting even the constitutionality of the declaration that was made. We are saying that she violated Article 23 of the Constitution because she is an administrative body. We have also said her exercise of discretion was contrary to Article 296 of the Constitution. These are all germane issues under the Constitution and laws of Ghana. And to reduce the petition into a single issue petition is rather unfortunate and smacks of a predetermined agenda to rule against the petitioner in this matter.
The court has said over and over again, and we hope that our colleagues on the other side will pay attention to what the court is saying. The court has said that you cannot compel her to get into the box. She will elect. Indeed, your own argument earlier was that she had elected to get into the box. And the court, after listening to the argument, showed that no election had taken place. So that argument falls flat on its face. Why do you now come and tell the people of Ghana that the Supreme Court is shielding her and preventing her from getting into the box? Because she is somebody or a party who you have brought to court. And the rules settled from the beginning that you cannot compel her. So it is not about truth. Some truth which you say you have left at home. And you are asking the court to drag the EC chair into the box so that you can conduct some surgery on her and find the truth out of her. It is about a legal argument of whether or not she can be compelled into the box to give evidence. And indeed, if you have some truth, why don't you lay it before the court? Why are NDC supporters now saying they should withdraw? Because they are observing before their very eyes, as this thing is televised live on TV, that their petitioner and their lawyers are not making a convincing case before the court. What they told them is not true. And that is why now they are asking the court to reopen their case so that they can put a party on the other side in the box and compel her to testify to make their case. It's becoming clear right before your very eyes that this is the reason for which their own supporters are telling them that it is about time that they abandon their case. But we want to conclude by dealing with this argument they make that they are doing this for the people of Ghana and they are doing this in defense of the Constitution. We vehemently disagree. What they are doing, this so-called petition before the court, is not for the people of Ghana or in defense of the Constitution. It is for the political interest of Mr. John Dramani Mahama, who desires this media spectacle to sustain his brand equity and run again unopposed in the NDC in 2024. Let's be honest about it. It's not in defense of any constitution, because if it was, the Constitution says that our legal system is adversarial, and therefore you can't compel a party in the box. Why would you be claiming you are defending the Constitution and asking the Supreme Court to turn the Constitution upside down?